G'day everyone, and welcome to topic 12 for laws 13010, evidence and proof. This week's topic is about criminal procedure and evidence. My name's Anthony Marinac, but you've probably figured that already. This topic is newly added to the evidence and proof course. It's one that previously was not taught as part of this course, but it's been added to this course during a redesign of the degree, where it was decided to do away with the old advanced criminal law subject and to move some of that material around so that people still get that material, but they get it delivered through other subjects. And as you will have discovered along the way doing the evidence and proof course this term, you will have found that we've really been talking mainly about criminal law anyway, and what you'll see is that the stuff that we're going to be talking about in terms of criminal law dovetails very neatly with the rest of the evidence program. So, what are we going to be talking about? First thing we're going to be talking about is types of criminal offence in Queensland. We're going to talk about arrest and summons and what they are and how they work. We're going to talk about the powers that police have to search vehicles and search places. Now, one of the types of place that they can search is a crime scene, and police have specific types of powers at a crime scene. So we're going to look at what crime scenes are and what powers police have in those scenes. We're going to look at the circumstances in which police can require somebody to provide what's called biometric data. So in other words, things like fingerprints and DNA samples and hair samples and blood. Finally, we're going to talk about the processes of bail and the process of arrest, or really that should be arrest and bail because arrest comes first. So let's begin. We start by thinking about types of criminal offences, because whilst there are many types of criminal offence, they really do run a gamut, don't they, from very, very serious types of offence down to things which we know are still wrong, still things that people shouldn't do, but which really are not on the same level. So at one end you might be talking about murder, manslaughter, offences against children, sex offences. These are really serious types of things. At another level you might be talking about jaywalking, which is still a contravention of the law, but obviously is at an entirely different level. Now, it would make no sense if every time somebody jaywalked, they ended up before the Supreme Court and a jury of 12 people trying to sort out whether or not they jaywalked. It would just be a waste of resources. So we split our criminal offences into a number of types. At the most serious end, we have what are called indictable offences. Now, they're called indictable offences because one of the first parts of the process, the court process, is the presentation of an indictment. So the prosecution presents a formal statement of what the person is accused of doing. Indictable offences are split into crimes and misdemeanours. Now, nowadays, the distinction between crimes and misdemeanours is basically nil, and you can really treat them as though they are the same thing. So indictable offences are serious offences. They're offences where if the person is convicted, prison is clearly on the table, and it's actually quite likely that that time in prison will be measured in years rather than in months. Simple offences are offences which are still considered to be criminal offences, but which are less serious than indictable offences. So we're talking here about, for instance, a lot of driving offences, a lot of offences that are contraventions of the road rules are likely to be simple offences rather than indictable offences. And so there is still going to be enforcement of those. There's still going to be a trial. If the person pleads not guilty, it's much more likely to be heard by a magistrate, and the offences tend to be much lower. Now, when we think about criminal law, we're really only thinking about those indictable offences and simple offences. The other two dot points that you can see on the screen still fall within criminal law, but they're a little bit different to what we traditionally would think of being as criminal law. The first ones are bikie offences and terrorism offences. Now, the bikie offences are known in Queensland as the VLAD offences, the vicious, lawless, vicious, lawless association disestablishment offences. I can never remember that acronym for some reason. Look, I prefer to call them bikie offences because I actually think it was really stupid when the government brought in that legislation, that it legislated with such emotive language. That really was, I think, playing politics rather than trying to make good law. So look, everyone calls them the bikie offences. Let's just call them the bikie offences. Now, a lot of these have been wound back considerably since the end of the Newman government in Queensland. And so they're not quite as offensive as they were. But for a period of time in Queensland, merely by being around other people, people who were accused of being part of a bikie group could find themselves stripped of a range of the normal rights that one would have under criminal law, and in fact the courts could find themselves stripped of certain sentencing options that they previously had. It's not quite as bad now as it was then. There are, particularly in Commonwealth law, a range of offences relating to terrorism, and those terrorism offences do restrict the rights that a person has after being arrested, and essentially the government would argue that the reason that those restrictions are in place is so that when a person is arrested for a terrorism offence, that they're not able to communicate to the rest of the terrorist cell or their other terrorist associates in a way that might result in, for instance, the acceleration of a terrorist attack. So really anything to do with bikies and anything to do with terrorism, all you need to know at this point, and for the purpose of this subject, is that you really need to have your spidey senses tingling and go back and check the legislation, because it's very, very likely that the laws and procedures relating to bikies and terrorists are going to be different to those relating to your garden variety criminals. I will drop you the big hint though that bikie and terrorism offences are really very unlikely to show up in your assessment for this subject. Finally, we get to regulatory and administrative offences. Now, regulatory and administrative offences are still offences, but they're offences which are really at a much lower level, and so an example that I might give is refusing to vote or refusing to participate in the census. These are things that might result in you getting a fine or something like that, but it's hardly the crime of the century, and it's really just a refusal to participate in a regulatory or administrative process. And so it is an offence, it will be dealt with as an offence, but it's really at the lowest level and doesn't always attract the same, I guess, moral considerations that we would normally associate with criminal offending. So we're going to focus most of our attention today on the indictable offences, and we're going to start by thinking about arrest. Now, we've all got a basic idea of what arrest means, that we've all seen movies, we've all seen the police pile on and arrest somebody. And the fact that you see most arrests being undertaken by police tells you that arrest is a policing power rather than a criminal procedure. So when somebody is arrested, that is the actual start of the criminal process. So the decision to arrest somebody is made before that criminal judicial process has begun. So it's made by a police officer in the exercise of their powers under the Police Powers and Responsibilities Act, and also in the exercise of their common law powers that have come down to us through the centuries. Now, when police arrest somebody, there is no magic formula of words that they need to use. And in fact, they don't even need to use physical force. They don't need to be touching a person even to arrest that person. As soon as the police officer makes it clear to a person that they are no longer at liberty, that they may no longer simply walk away and leave the conversation, the police have arrested that person. Now, One of the questions that people ask is, well, what if I know I'm innocent? If police have arrested me and I know that I'm innocent, well, then aren't they arresting me falsely? Well, the answer is no. The power can validly be used on an innocent person, because when the police arrest somebody, essentially what police are saying is, you are now going to face a criminal process which will determine whether or not you are innocent or guilty. And so being arrested doesn't actually make any presumptions about a person's innocence or guilt. What being arrested does is says this is a person who police believe should be brought before the courts. If that person turns out to be innocent, well, it's the role of the courts to say so. And so that doesn't invalidate the arrest process in the first place. Many arrests are undertaken with a warrant. So we've all heard of arrest warrants. Well, they really do exist. In most cases, they're issued by a magistrate or by a justice of the peace, and they're issued when the magistrate or the justice has reasonable grounds for believing that an offence has been committed. Now, look at those words really carefully. Earlier in the term, we talked about different standards of proof. Well, this is really just about as low of a standard of proof as you could get, isn't it? So the warrant can be issued if the magistrate or justice has just reasonable grounds for believing. So you can see why it may be that innocent people might get arrested, because you could have reasonable grounds for believing that an offence has been committed and yet still be a long way from being sure beyond reasonable doubt. And so many people will fall into that middle ground where there's enough there to arrest them, but it turns out at the end of the day that there wasn't enough there to satisfy a court beyond reasonable doubt. And that's why the arrest can be valid even in the event that a conviction doesn't occur. Now, there are other sorts of arrest warrant too. For instance, what's called a return to prison warrant or a return to an institution. Now, return to prison warrant usually happens where somebody is out on bail and they have, or somebody's out on parole and they have breached the conditions of their parole or their bail. And so if, for instance, if they're required to report to police on a regular basis and they stop doing it, or if they're required to submit a drug test and they fail that drug test, then it may be that there's a warrant issued to return them to jail. Return to an institution, you'll generally see where somebody has been detained under the Mental Health Act for involuntary treatment. So they're under an involuntary treatment order, and they might be released from the treatment institution, say for a weekend, for weekend leave with their family, and then fail to return. And the police will be used to help find that person and return them to care. Now, a warrant is issued to allow police to involuntarily detain that person, but it's not issued to try and bring the person back before the courts for punishment. You've got a person out there who needs to be in care and who is not currently in care. And so the warrant simply provides police with the authority that they need to take that person back to the place of care, whether they like it or not. Lots of arrests, however, happen without warrant. And this is a power that police can exercise on their own. They need two things. First, they need reasonable suspicion, so there's that low standard of proof again. Reasonable suspicion that a person is committing or has committed an offence. They also need to believe that the arrest is necessary to do one of a range of things. Either to prevent the person from committing any further offences, or if it's likely that the identity of the person is going to be an issue, then it may be necessary to arrest them in order to have them properly identified. Preventing interference with people or property, so if the person is not necessarily in the process of committing any further offences, but if they're likely to interfere with other people or property in a way that is not appropriate, then they might be arrested. Most importantly, though, as a subset of that, is to prevent interference with evidence and witnesses. So if a person is trying to destroy evidence of an offence that they've committed, if they're trying to pour drugs down the drain or whatever it might be, or if they start swearing at witnesses and police believe that there's a chance that they may threaten witnesses or do something like that, well, those are very good reasons for a police officer to arrest the person. Finally, if the arrest is necessary to bring the person before the court. Now, there will be many occasions where none of those conditions are true, where a person has committed or is committing an offence and where police investigate them or catch them, but it's not necessary to arrest them to prevent any further offences. It's not necessary to arrest them in order to identify them or in order to prevent them from doing other stupid stuff, and there's no reason to believe they're not going to show up in court. Well, under those circumstances, there would be no reason for police to arrest the person, and in that circumstance, you would expect the person to be given what's called an NTA, or a notice to appear, so that they will be essentially summoned before the court without any need for them to be arrested. So arrest is not automatic just because you've got an offence having been committed. So a person's been arrested. Having been arrested, they can be detained. Now, they're usually going to be detained in a watch house. If you ever get a chance to visit a watch house, you should take that chance. And if you've never had a chance to visit a watch house, it would actually be a really good thing for you to do, to contact your local police, tell them that you're a law student, say that you've been learning about criminal law and that you've been learning about what happens to a person who's arrested, and just ask them, would it be okay if I come down at some point when it's going to be relatively quiet and have a look at the watch house and perhaps learn from you what the process is when you arrest someone? Chances are that they'll be perfectly happy to walk you through that process, provided that you are happy to go along there at a time when they're not going to be busy, because watch houses can be a very busy place. Now, what you will find if you ever get to see a watch house is that they are really quite Spartan. They're intended to be suitable for prisoners to stay in for no more than a couple of days. They're usually just a built-in sort of cot ledge with a mattress on it. The person will be given a blanket, and there's a toilet hand basin available to them, and usually not a lot more than that. Most people who are in the cells spend their time either screaming and carrying on or sleeping. Generally speaking, people are not in the watch house cells for more than a few hours, because generally speaking, a person who is arrested will be brought before the magistrate the following morning. And you know, probably the majority of people are arrested in the afternoon or evening. You don't want to get picked up on a Friday night, though, because if you are picked up on a Friday night, or your client is picked up on a Friday night, then they're quite likely to remain in the watch house until they can go before a magistrate on Monday morning, unless they get bail in the meanwhile. So that's not fun. So the bottom line is that once a person has been arrested, they remain arrested until they're brought before a magistrate, and so they can be detained in the watch house during that period of time. They can also be bailed. Bail is a process where a person is released from the watch house. They're released from arrest, but they're released on their undertaking that they will present themselves before the court. Now, bail can be given in two ways. First is bail can be given by police. So the officer in charge of the police station, or the watch house officer, may bail a person, and they will require them to appear before the magistrate on whatever day it is that it says on their bail notice. It can also have additional conditions, such as a reporting condition or a drug testing condition or something like that, and the person will have to abide by those. Now, of course, when I say that, the person doesn't have to abide by those, because the person doesn't have to leave the watch house. So you don't have to accept bail if you don't want it. But let me tell you that most prisoners, or most people who've been arrested, are really looking forward to getting out of that cell. The other way that somebody can get bail, police bail, happens pretty much straight away. It's quite likely that somebody who gets police bail will be back out on the streets a few hours after they were initially arrested. Court bail takes a little bit longer. You've remembered that I've said a couple of times now that after a person's arrested, they'll be brought before the magistrate. Well, one of the things that they can do, and one of the things that you as their legal representative will do, is make an application for bail. Most of the time, an application for bail will be successful and the person will be released by the magistrate on their undertaking to come back before the courts at a particular time. Sometimes the magistrate will require what's called a surety, okay, which is a payment of money, which will be forfeited in the event that the person doesn't show up for court. Sometimes, in fact, very often, the magistrate will impose conditions of bail that include regular reporting to a police station, maybe once a week, and that also require the person to obtain permission if they want to travel away from their local area or travel outside Queensland. Quite often, a person will not be able to travel overseas without special permission while they're on bail. In some cases, though, a person will not be bailed by the court. This is typically when the crime is really serious, or when the person has a long track record of breaching their bail conditions, and so they just can't be confidently released back into the community. In that case, the person will be remanded. Now, when a person is remanded, they go to prison. Okay. In some places, so for instance, Brisbane has the remand centre out at Waco, which is set up just for remand because there's going to be a lot of people around there. But if you go to places like Maryborough Prison or Capricornia Prison near Rockhampton, then you'll find that the remand prisoners are just in with the general prisoner population. Now, because they're essentially starting a prison sentence then and there, if they are convicted or if they plead guilty to whatever it is that they're charged with, then that pre-sentence custody will be taken into account. So quite often the sentence will commence as at the date that they were initially taken into custody, rather than the sentence commencing at the date of sentencing. So that's arrest and bail. Let's take a step back though. Let's take a step back to the point of arrest, and in fact prior to arrest, and start thinking about search and seizure. And this really brings us back to evidence, because when police search somebody and when police seize things, what they're looking for is evidence. They're not just taking stuff off the person for the heck of it. They're looking for things that may assist in the successful prosecution of that person or another person. But there are rules about search and seizure. Okay, it would be a horrible, horrible community if police could simply walk around and stop whoever they wanted under whatever circumstances they wanted and just seize people's stuff and search those people. I wouldn't like living in that community at all. So we do have some rules. Let's start with the arrested person. Now, an arrested person is definitely going to be searched, and really they have to be searched. And that's for their safety and for the safety of the watch house staff. So we're not going to let someone go into a cell and find that they've still got drugs on their person. By the same token, they're very careful about what are called ligatures. So they're very careful to make sure that prisoners do not have means to harm themselves when they're placed in the watch house. Most of the stuff that a person brings in with them when they're arrested, though, will simply be kept in safe storage and receipted for the person, so that when they are released on bail, they will be able to get all that stuff back. Evidence, on the other hand, anything that's likely to be evidence can be seized. Now, interestingly, that rule goes beyond just evidence of the crime that they were arrested for. So you might be arrested for something, and then when the police have you turn your pockets out, they find other stuff in there that relates to other offences that they might be interested in. Well, that can be seized as well. Okay, so it's anything that's likely to be evidence of any offence can be seized. Now, other people who are not the arrested person can also be searched. They can be searched if the police officer has a reasonable belief that they have a range of items on them. Now, you'll find those items listed in the notes and in the statute. Essentially, if the police officer has a reasonable belief that the person has weapons on them, then they can be searched. If a police officer believes that they have drugs, if a police officer believes that they have evidence, if a police officer believes that they have stolen property on them, then of course they can be searched. And if that search results in the police officer having the grounds for arrest, then that person can obviously be arrested. So that's search of persons. Let's move on now and talk about search of places. Now, the search of places is generally undertaken with a warrant. Okay, so before a police officer searches a place, they generally are required to go and see the magistrate or justice and make sure that the magistrate or justice is reasonably satisfied that specific items that the police are looking for will be at the place within 72 hours. Now that warrant allows police to go into the premises, to look for those things, to seize those things and take them away. The warrant also usually requires the occupier to assist police when they're doing that, and it requires the occupier to hand over documents that they might have and to unlock computers. So, for instance, you might have somebody who's suspected of viewing child pornography online, and police turn up with a search warrant, and you can imagine the situation if the defendant was able to turn around and say, well, you know, good on you, go your hardest, but I'm not unlocking the computer and I've got an encrypted hard drive. By doing that, they would essentially be able to defeat justice. So the warrant requires that person to unlock computers and make them available to police. Now, there's another type of place, though, that we need to be really careful about, and that's a crime scene. You see, quite often when police get a warrant to search a place, it's not necessarily a crime scene. It's just somewhere where they think evidence might be. Crime scenes are a bit different. A crime scene can be declared by a police officer if it's a place where a crime with a maximum sentence of 7 years or more has taken place, or if it's necessary to declare a place to be a crime scene in order to secure evidence. And this is what happens when you see those police tapes set up as temporary barriers around things that people are not supposed to cross that police barrier. Everywhere within that barrier is declared to be a crime scene. And so they'll have scenes of crime people there who are processing the evidence from that scene. So the idea of that crime scene is to prevent contamination of the crime scene, to prevent contamination of any of the evidence. And now that you're at the end of a course in evidence, you can really see the importance of that, I think. There's two types of crime scene, primary and secondary. The primary crime scene is literally the scene of the crime. That's where the things happened that lead police to the view that a crime has been committed. The secondary crime scene contains evidence of a crime committed somewhere else. But really what we're talking about there is not just a place that might contain evidence, because then you'd just get a search warrant for that place. We're really talking about a place where the place itself and everything that happened at that place is potentially evidence. So if you get someone who murders a person in their home and then endeavours to dispose of the body in nearby bushland, well, the home is going to be the primary crime scene. And the bushland where they're trying to dispose of the body will be the secondary crime scene, because it's not the scene where an offence has occurred. It is the scene where activity relating to that offence has occurred, and it's really it's not just items in that place that are going to be of interest to police, it's the whole place itself. Just before we move on from crime scenes, one thing to note is that a public place can be declared a crime scene, even though a police officer wouldn't normally need permission to go into a public place, but they can declare a public place to be a crime scene, and that tells everyone else that it's no longer a public place. They can't go past that tape. Let's move on to search and seizure of vehicles. Most commonly, vehicles are searched by consent, and so if police say we want to search the car, the person who's in control of the car says, yep, go your hardest, then police can indeed go their hardest. They can search a vehicle without a warrant, if there's a reasonable suspicion the vehicle's being used unlawfully, so for instance, if the plates don't match the vehicle, if there are no plates on the vehicle, if the vehicle has been reported stolen or anything like that. Now, reasonable suspicion the vehicle is being used unlawfully, that doesn't mean speeding. That doesn't mean they saw you going through a red light and that gives the police the right to search the vehicle. What we're talking about here is stolen or unregistered vehicles. If they have a reasonable suspicion the vehicle contains someone who can be arrested without a warrant. Okay, so crime has just been committed, police believe they know who committed that crime and they see that person in the vehicle, well, they're entitled to stop the vehicle and they're entitled to search the vehicle. Finally, if they have a reasonable suspicion that the car contains contraband, weapons or evidence. Now, this is one where when you're looking at potentially a voir dire for a trial, you need to be really thinking, anytime police have searched a car, you need to start with the thought, well, how did they get their power to search the car? And if the power came because they had reasonable suspicion that the car contained contraband, weapons or evidence, well, you'd be then thinking, where did that reasonable suspicion come from? What was it that led police to have that reasonable suspicion? And if there are no good answers for that, it may well have been a search that was conducted unlawfully, and you may well be able to have that evidence chucked out for the reasons that we've discussed earlier in this term. So, questioning. Person's been arrested, taken back to the station. We've already talked quite a bit in this course about confessions and admissions and the fact that they can only be used in court, they can only be admissible if they are taken in circumstances which are fair. A person who has been arrested does have the right to remain silent, just like you've heard in every bad crime movie you've ever seen. They have the right to communicate with a friend, relative or lawyer. Now that's just the right to communicate with a friend, relative or lawyer. In Australia there is no absolute right to a lawyer. So you've heard on American TV, if you cannot afford a lawyer then one will be appointed for you. Well, not in Australia. There's very limited access to legal aid in Australia. If a person doesn't have a lawyer and doesn't have the means of retaining a lawyer, then they can communicate with a lawyer. They can say, what's your fee? The lawyer says a whole lot of money. The arrested person says, I can't afford that. Well, then they've had their opportunity to communicate with a lawyer. Okay? If they can't afford a lawyer, then that doesn't stop the process. There are special rules for children, Aboriginal and Torres Strait Islander people, impaired people, by which I mean people who are not necessarily mentally competent, and intoxicated people who have to be allowed to sober up. For the rules for children and Aboriginal and Torres Strait Islander people, go and have a look at the Police Powers and Responsibilities Act and you will find those provisions set out there. Generally speaking, people who are impaired by a mental illness or a psychiatric disorder or a brain injury, the question is going to be whether they're likely to be able to recover. Otherwise, it may be possible to interview them with a friend or guardian present, and in some cases it won't be possible to interview them at all. Intoxicated people, remember that intoxication also refers to intoxication by a drug and not just intoxication by alcohol. Cautions. Now the caution is, if you've watched bad American TV, you hear them talking about their Miranda rights. Well, we don't have Miranda rights in Australia, but we have something pretty similar. The caution is basically an opportunity to tell the arrested person that they don't have to speak to police, but that if they do speak to police, then what they say will be recorded and may be tendered as evidence. Again, as we mentioned earlier with arrest, there is no specific set of magic words. The content is more important. As long as the person understands that they have those rights, then the requirement upon police has been met. Now, cautions only need to be given in relation to indictable offences and not in relation to simple offences. Very often, though, police will give that caution even in relation to simple offences because they might be arresting somebody for a simple offence, but they might then later discover that they also have grounds to hold that person for an indictable offence. And, well, it's a bit late at that point to be giving the person the caution after they've already been communicating with and cooperating with police. The questioning has to be recorded if it's practicable to do so, and a copy of that recording has to be provided to the interviewee. So if your client participated in an interview, the first thing that you want to be asking is, well, where's my copy of that interview? Because you should be able to get it. In many cases now, you're not only going to be able to get a copy of the formal interview conducted back at the station, you're also going to be able to get a copy of the actual moments of arrest and the initial interaction between your client and police, because most police now carry digital video recorders, many of them wear body cameras, and so there's all sorts of information available. Now, whenever I mention this, people say, well, can a police officer just record me, and can I just record them? The answer is yes. In Queensland, permission is not required to record a conversation if you are part of the conversation. Now, there are a few things to think about there, though. First is that doesn't count for telephone conversations. Okay, if you're having a telephone conversation with somebody, that comes under Commonwealth law, not Queensland law, and you need their permission to record that conversation. Second, you cannot record either by video or by audio. You cannot record people on what we might call occasions of intimacy unless that person knows that they are being recorded. So you cannot covertly record sexual activity, for instance, unless or you cannot covertly record it. The other person must know what is going on. So I guess the final thing that I'd say about recording conversations is that whilst a person can record police, can record their interactions with police, there are ways and ways to do that. If your client goes out of their way to be aggressive towards police, to aggressively get in the police's face with the camera and say, I'm recording you, then it's quite likely then that certainly police will be very professional, but they're not going to be quite as disposed to be pleasant to your client. A little bit of common sense and a little bit of passing the attitude test goes a long way. Finally, we come to forensic procedures. Now, forensic evidence, as we've already said several times through this term, forensic evidence has really turned the world upside down as far as evidence goes, because until about 1989 there was no such thing as DNA evidence, and the whole world of criminal offending has just changed completely since then. Fingerprinting and photography have been routine for a very long time. And generally speaking, there's no difficulty about that. An arrested person will have their fingerprints taken and will have photographs taken. We're more concerned with the more invasive process, so provision of hair, provision of body fluid. The most common body fluid that's taken is saliva, which will be taken by a saliva swab, either for DNA purposes or for drug testing. It's also very common to take blood, particularly after a person has blown over a roadside test for their blood alcohol content, and it's also occasionally necessary to take other bodily fluids in terms of sexual offences, and there's probably no need to be any more detailed than that. Generally speaking, consent will be asked for. Generally speaking, consent is given. It does look very suspect, I think, if a person refuses to give consent. There are limited circumstances in which the refusal of consent is quite normal and won't be thought too much of. If a person has a terrible phobia of needles and doesn't want to give blood, well, I think most people can find it in themselves to see how that might work. Some people come from a religious background that makes these forensic procedures problematic. If a person refuses to give a sample, then police can apply for what's called a forensic procedure order, which will allow them to have that forensic procedure undertaken essentially involuntarily. Now, all of these more invasive processes have to be done by a qualified person. So you're not just going to get Constable Plod sticking a needle in you to take a blood test. These things have to be done by people who have the appropriate qualifications, usually doctors or nursing staff. So there we have it. This week we've looked at the difference between the different types of offences. We've looked at what happens to give police the right to arrest somebody either with or without a warrant. We've looked at, after that arrest, what happens in terms of the person getting police bail or court bail or going off to remand. We've looked at when police can search places, vehicles and people, and within places we've looked specifically at crime scenes. We've looked at the processes for properly conducting interviews, particularly those of suspects, and we've looked at the processes for obtaining biometric data such as fingerprints and DNA. So that brings us to the end of the evidence course, including the additional material that's now been added in relation to advanced criminal law. I do hope this has been helpful. By now, when you hear this, you'll all be thinking very hard about preparation for your exam. I promise that we won't make it too hard for you. Good luck, and may the force be with you.